Good morning, everyone. I am Ana Luisa Neri, Cultural Director of Instituto dos Advogados de São Paulo, and I'd like to thank the Instituto on behalf of its president, Professor Renato Silveira, for offering us this space to debate a highly relevant issue, to deepen our studies and our practice in law, which is the value through the legal sector. Today and tomorrow, we gather important both national and international references and leaders to be with us and to talk about the following main topics: commercial arbitration, dispute funding, securities litigation and portfolios monitoring, antitrust litigation. And I would like to greet our distinguished speakers whose presence in this meeting really honors us. It's a great pleasure for us to welcome you to this house. So before presenting this panel, this first panel, I should thank in particular to Eric Moura, which knows the themes of the seminar very deeply, and besides whom I had a great satisfaction of coordinating this seminar. Thank you very much, Eric. So now allow me to present to Maria Carolina Neri, who will be moderating the first panel of our event. Carolina holds a master's degree in civil law from the Pontifical Catholic University of São Paulo, Brazil. She has an LLM in global business law from Columbia University, New York. She also received a master's degree in languages and literature from Julius Maximilians Universität in Würzburg, Germany, and she's a partner of Neri Advogados. Welcome, Carolina. So after this brief introduction, I would like to express my thanks to all those watching us and invite you to access our website, in which in a few days, the seminar will be available in full. On the website, it is also possible to access the content of all events we have been producing in the Institute, and on the most different legal and cultural themes that we hope can be useful for the improvement of professional practice of legal careers. Finally, I thank the participants based in other countries, as well as the Instituto for the opportunity granted us to coordinate this seminar and thus fulfill one of our noblest institutional missions, which is the study of law, the dissemination of legal knowledge, and the cult of justice. So I'm now pleased to hand over Carolina Neri, and shall leave you to join the viewers. I wish you all an excellent event. Thank you so much.
Thank you, Anna, for the kind words. In my name, I also thank very much the invitation from IASP, and thank its president and its cultural director, you and Professor Renato, for organizing this event, for holding it and allowing us to talk about such relevant matters. And also to Eric, who had the initiative to organize this event together with us and to start this panel on the trends of commercial arbitration, which is the introduction to this two-day seminar. I would like to introduce our speakers, Nilüfer Hossein and Max van Leyenhorst. Nilüfer has received her JD from the New York University School of Law, her MA from Middlebury College, and her BA from Harvard College, where she graduated magna cum laude. Nilüfer is admitted to practice law in California, New York, and New Jersey, and provides legal analysis and strategic advice on funding international arbitration and commercial litigation matters based on nearly 15 years of combined experience as a funder, in-house counsel, and a practicing attorney with top legal global law firms. And she also sits on the advisory council of the New York International Arbitration Chamber. And now she leads Omni Bridgeway's international arbitration initiatives in the United States. Nilüfer is a member of Omni Bridgeway's Latin America group and contributes to its international arbitration, litigation funding, and judgment enforcement efforts in Latin America. Max, Nilüfer, welcome to our event. Thank you very much for participating, and we are looking forward to hearing your thoughts on the trends of commercial arbitration. And Max is a partner at legal law firm based in the Netherlands, and he specialized in international arbitration, acting as a counsel and also as an arbitrator. Max has taught a number of arbitration law courses in the Leiden University, and he's the co-founder of the Dutch Arbitration Association and regularly publishes on arbitration-related topics. Thank you, Max, for being with us and also sharing your thoughts on the common trends of commercial arbitration. I welcome you too, and I'm looking forward to hearing your thoughts on some topics that we have selected. Of course, there are many trends on commercial arbitration nowadays, so it was a kind of a hard job to select only some of the issues to talk about today. And the first one I would like to us to start talking about is the question of gender equality in commercial arbitration, which I think is a very interesting topic, at least from our point of view in Brazil, because we are having a kind of a change, I would say, in our arbitration chambers. The most prestigious ones in Brazil are being directed by women nowadays. And that just strikes me as a very interesting question that I thought about addressing today. And that's, of course, a perspective from a Brazilian practitioner looking at the arbitration chambers. And I don't know how you guys see this issue being handled also in America and in Europe. And I would like to hear a little bit about you, from you about this issue. Maybe Nilofar, you would start, ladies first.
Thank you very much. And thank you very much for inviting me to speak on this panel. It's a pleasure to be here. And I thank your audience for joining us on this important event. So with respect to gender diversity, I can speak on behalf of how we've funded cases globally, at least at Omni Bridgeway. As your audience will know, we're one of the largest third-party funders around the world, and we fund arbitrations not just in the US, but also throughout Latin America and across the globe. And something that our practitioners at Omni Bridgeway are quite cognizant of are improving gender diversity amongst arbitral tribunals, as well as improving gender diversity on counsel teams for that are representing claimants, or in some instances who are representing respondents. So Omni Bridgeway is a member of the Equal Representation and Arbitration Pledge. That's something your viewers may be familiar with. It's a global initiative to really do just that, to improve the numbers of women that are appearing on tribunals, as well as to improve the number of women that are taking the lead as counsel in these critical international arbitrations. I think there's a lot of discussion. It's very de rigueur to speak about gender diversity on international arbitration panels, and the numbers have improved slowly. I'd say the work that still needs to be done is probably more on the age ranges of international arbitration panel members. It tends to be people who are quite distinguished in their career and have practiced for a larger number of years, which is lovely. But I think it prevents a lot of younger female talent from getting opportunities. And I've participated in a number of gender initiatives, both as part of Omni Bridgeway and just part of through my network in international arbitration. And it's something that I'll flag for your viewers, because I think there's a number of great initiatives out there for younger female younger female arbitration practitioners who are interested. And one of those initiatives is called the Mute Off initiatives, which is a group of women practitioners across the globe who meet once a week to discuss key issues in international arbitration. And they get a series of speakers that talk about critical issues in the field, both in commercial cases as well as in investor state cases. There's also the Equal Representation and Arbitration Pledge, which has subcommittees around the globe. There is a Latin America subcommittee if any of your viewers are interested in being more involved in that. And then there's also another organization called Arbitral Women, which also unites globally women around the globe, all working in arbitration. Some work in institutions, some work at law firms, some work at third-party funders like Omni Bridgeway and others. And all are working sort of towards the same goal. So I guess to summarize, there's a large number of initiatives out there to really focus on this issue, and we have seen baby steps towards progress. But I would say that improving progress means having more diversity, both in terms of age as well as racial diversity. There's still a long way to go in terms of racial and ethnic diversity on arbitral tribunals. But I'm optimistic that it's going to continue to change, because just the dialogue itself is so strong about about moving this in the right direction. And with that, I'll turn it over to Max.
Thank you very much, Niloufar. Thank you as well on my behalf to invite me on this panel, especially considering that I'm not the typical diverse contribution to panels these days. But we do see, and I think it's very good in as far as I can comment on it, we do see a lot is being done in terms of diversity, gender diversity, that is. Other diversities are still pretty much lagging behind. But in gender diversity, we see that all the major arbitration institutions are now headed, well, not all, but most, by women. We have the London Court of International Arbitration headed by a woman, the ICC Court headed by a woman, Netherlands Arbitration Institute as well. It's a different category perhaps, but it's also the Director General is a woman as well. And I think you see the effects. It helps in at least the arbitral institutions appointing more diverse than they might have done in the past. In the Netherlands, the Arbitration Institute had the appointments that it made last year was 50%, the direct appointments by the Arbitration Institute, 50% male, 50% female. In general, however, I think that the numbers are around 25%, and I understand that that's also the situation in Brazil. That resembles the percentage in the Netherlands and I think also with the ICC. It's all around 25%, which is better than it used to be, but not quite good enough. I think it makes sense to appoint female arbitrators in the tribunal, not just because it sounds good, but I think it functions well. As you said, I also sit as an arbitrator and I act as counsel. And I think a tribunal just functions better, more balanced, if there's also a female arbitrator. And with the risk of being too generic in my approach, I think female arbitrators tend to be sometimes more or better prepared than some of my male colleagues. So there is a certain advantage in appointing female arbitrators, and it's not just something to do because it's right. It's just it's good for your clients as well, and it's a pleasant way of working as a co-arbitrator if the tribunal is mixed, not just gender mixed, but mixed in in general.
Yeah, Max, and you also talked about, and Niloufar also, about the age diversity, which also strikes me as being very important, that you don't only take very experienced arbitrators, who is obviously of advantage, but also people who have maybe more time to dedicate themselves to analyzing the cases, and that also strikes me as something very relevant. Yeah, in any way, I would say that, at least in Brazil, I see the chambers raising awareness to this question as a first step. No? Of course, you can't change the way the legal teams are composed right away, and you also can't make parties choose a certain set of arbitrators to compose a panel, but obviously it's a first step to raise awareness and also to see people thinking about these issues as being relevant, and also seeing the consequences and also the advantages when you have an arbitration that counts on a diverse panel. Also, something that strikes me as interesting is that, and that information we have from one of the directors of a prestigious arbitration chamber in Brazil, is that women usually don't apply for the job of arbitrator, because arbitration chambers in Brazil, they have a list of arbitrators they suggest to the parties that come to them for arbitrations. And this list is obviously composed by the arbitration chamber. And usually people apply to be part of this list. And what the information she's shared with us is that women usually don't apply for that. So maybe that's also something that needs to be changed among young practitioners, female practitioners, is that maybe they are good enough for the job. Maybe they are already prepared and they should put themselves out there. So Niloufar, thank you for sharing with us these initiatives that are happening nowadays, and that that gives an incentive to younger women to, you know, prepare themselves for these jobs that are out there, and maybe call them out to that. Thank you for that. Maybe we should change.
Carolina,
yes.
If I may add to that, I think in my experience, if again, it might be too generic, but generally, if a female arbitration practitioner doubts whether she is qualified to be an arbitrator, she probably is. When a male arbitration practitioner doubts whether he is qualified, he probably is not. That's so if female arbitrators are out there wondering whether they should be on the list or should apply to be an arbitrator, I would say go ahead and get on the list.
Thank you, Max. Yeah. As I said before, it's very difficult to narrow down our topics of discussion for today, but one other question that we thought might be interesting to talk about is that, well, from our perspective, of course, in Brazil, our statute that regulates the stock market allows since 2015 for companies to include arbitration clauses in their bylaws. And that obviously increased the number of arbitrations involving investors. And that also increased the number of international parties who want to start an arbitration in Brazil. And that just strikes me as being an interesting topic for us to discuss as international partners here, because Max, obviously you represent European parties, and Nilüfer funds international arbitration. So maybe you can talk a little bit about how you see investors that tend to look for arbitrations in Brazil, or obviously look for to claim for indemnification from companies located in Brazil. How do you see that as a new business growing here? Nilüfer, would you like to start?
Sure. So this is a topic I'll admit I'm still learning a little bit about. I haven't come across too many requests for funding from from under such circumstances, but it's certainly something we'd be interested in learning more about. It would be helpful, Carolina, to understand a little bit more about this, though. Like, what institutions are they putting in their contracts? Is it local institutions that have the dispute resolution clauses?
Brazilian companies, stock companies, because the bylaws are obviously public and they are not simple contracts that each investor can close with the company. It's a given bylaw that the investor has to agree to when they buy stock. So that's why it was a question if the arbitration clause should be included in it or not, because it's not a normal contract that you can negotiate. But then it was allowed. And it's understood that if you are an investor and you buy stock from a company that has an arbitration clause in its bylaws, then you obviously agree to submitting yourself to arbitration if one day you wish to claim for indemnification. So that was a discussion, and then it ended up in the statute allowing for arbitration clauses in the bylaws of companies. And now what we see is, because then the first question was, is it going to be arbitrary for companies, or is it just a way for companies to avoid litigation? Because then if the investor needs to submit to an arbitration, maybe they will give up before starting an arbitration, which is a little more complicated than the litigation. But that's not the case. What we see is that we do have arbitrations being installed by investors anyway. So that's something that strikes me as being interesting, because we have seen arbitrations being started by minority investors. So maybe you can talk a little bit how the funding of arbitrations work abroad, because that's something that may start right now in Brazil.
Sure. Sure. So thank you for that explanation. And I do look forward to learning more about that topic. It's just, it hasn't come across my desk yet. I haven't gotten any requests for arbitration related to that, the change in circumstances in Brazil. But typically the way Omni Bridgeway functions is we get requests to fund arbitrations globally, and those requests come in from shareholders. They come in from the companies themselves that might be in a dispute with a counterparty. They come in also from legal teams around the globe, both Brazilian law firms. We fund Brazilian law firms. We fund law firms throughout Latin America. We also obviously fund globally law firms around the world. So I'm happy to answer questions at a later time about what our process is and so forth. But I'd invite you to ask Max the similar question, since I don't want it just to be about Omni Bridgeway.
Sure. Max, how do you see this issue?
Well, I think it's an interesting issue. I understand that this is relatively new in Brazil since 2015. And I had one question and one comment. One question is, do I understand correctly that new shareholders, even if they are not aware of the bylaws, I mean, not any shareholder who buys stock in a listed company will know about the bylaws and whether there's an arbitration clause in that. Are they also bound by the arbitration agreement? And a related issue is that we have in the Netherlands also the possibility to include an arbitration clause in bylaws of a company, and that is sometimes done as well. And that is obviously a valid arbitration clause. But still, the Supreme Court has held in the Netherlands that a dispute on, for instance, whether a corporate decision should be nullified or is null and void, that those kinds of disputes cannot be arbitrated. They are not arbitrable, because according to the Supreme Court, those kinds of disputes are not at the free disposal of the parties. So I wonder whether there's any limitation in Brazilian law that resembles that.
Yeah, that's very interesting. First, to your first question, yes, the investors are bound by the arbitration clause, even if they are not aware, because it's supposed that they should be aware of it. Once you buy stock, you should be aware of the bylaws of the company you're buying stock from. So that's it to the validity of the arbitration clause. But you raise a very important question, which is to the nullity or invalidity of some issues that might affect other investors and not only the party involved in the arbitration. So that's a very interesting question. I don't think that should be resolved in the single arbitrations. So in that effect, maybe we are also going in the same direction as the Netherlands. But it just strikes me as being interesting because, of course, in private companies, of course, you can include an arbitration clause as a valid clause. But what was very problematic was to allow that in stock company, because that's a little different. But of course, that the questions that involve public matters, they obviously can't be arbitrated. So that's also something to be considered when an arbitration starts, right?
In the Netherlands, even if you have a limitation that arbitration cannot be agreed on disputes such as whether a corporate decision is null and void, a party could choose to go to arbitration still if you just rephrase the claim a bit. And for instance, if you don't claim that the declaratory judgment that the decision was null and void, but instead you claim that the respondent company or the respondent shareholders ensure that a new and different decision is made or is taken, that is arbitrable. So it's also a matter of correctly drafting your claim, which will either lead to the claim not being arbitrable, or if you want to the claim being arbitrable. It's not a very black and white situation, fortunately.
Sure. It's always a question of how you phrase your claims, right? How you're going to narrow down your claims and what exactly you are asking from the respondent. Obviously, that's going to be a case-to-case question to be resolved. And to that point, We were talking about difficulties on enforcement also of arbitration awards and how sometimes they are challenged. And then maybe I think it was Nilofar in our last meeting suggested that we talk a little bit also about tips maybe we can give to people on how to avoid problems, let's say, both during the arbitration and also when it comes to the arbitration award. And also, since writing the arbitration clause and passing by forming the panel and coming to the award, what kind of caution, what kind of measures should we take to avoid problems that will lead to the challenge of an arbitration award, which is something that we also see growing as the numbers of arbitrations grow. Also, the numbers of awards that are challenged in the judiciary also grow. So maybe Max, if you want to start with that, I'm very interested to hearing what you see in your practice that maybe you can share with us as striking you as interesting.
Absolutely. I think first and foremost, if you want to diminish the chance of an arbitral award being set aside, it's all in the selection of the arbitrators. Of course, the seat is important because you want to have an arbitration act that works well, but I would prefer a good quality tribunal with a bad arbitration act over the other way around. Because if you have bad arbitrators and a good arbitration act, the arbitrators will still be able to derail the arbitral proceedings or render a terrible arbitral award. And if you have experienced arbitrators, which, well, you could go for the usual suspect, what you mentioned before, the more experienced ones. And I would advise to at least have one, or perhaps the chairman or chairperson, I should say, of the arbitral tribunal to have experience and to be experienced with the relevant arbitration act. But I think it's far more important to have high quality arbitrators. So the selection of the arbitrators is of paramount importance. Next to that, then, as I said, you should select a seat which has a proper arbitration act. Most of the audience will know, but I'll mention it just to be sure. The seat of the arbitral proceedings is just a complicated way of saying which arbitration act applies. So if the seat is in Sao Paulo, then the Brazilian Arbitration Act applies. And if the seat is in Amsterdam, then the Dutch Arbitration Act applies. It has nothing to do with where the hearings will take place. So if a opposing party says, well, I want the seat to be in South Africa because I want to have the hearing there, you can just say, well, let's have the hearing in South Africa, but the seat in, well, somewhere else, perhaps. And I know of war stories and have experienced war stories whereby the arbitral proceedings have just, well, derailed because of the selection of the arbitration, the seat. If you have the arbitration proceedings in a country which does not actively support arbitration, which does not have courts that support arbitral proceedings, then it might be difficult to prevent the arbitral award from being set aside at the end. So I think those are the two most important issues to consider, both of which the party should consider before writing their briefs, because those elements should be dealt with, in my professional opinion, even before you initiate arbitral proceedings, but in any event before you start submitting the written briefs.
And do you see more problems arising from, let's say, bad awards being rendered as maybe what we could consider not technical awards? Or do you also see problems arising from matters related to the independence of the arbitrators, or questions as to the proceeding itself? What strikes you as being more problematic right now?
I think well, both. I'm not sure what happens more often. You see both happening, and as long as the stakes are high enough, any procedural or merits problem will be will be invoked in setting aside proceedings. You see a lot that But in the Netherlands and also in some other jurisdictions, if you have an issue as a party with a perceived lack of independence of an arbitrator, that party must flag that immediately. If you don't flag that during the arbitral proceedings and you knew about it, or perhaps even you should have known about it, then you cannot raise that issue in setting aside proceedings. And even in setting aside proceedings, if you want to set aside the arbitral award on the basis of an allegation that the arbitral tribunal or an arbitrator was not impartial, then you really have to show that the arbitrator involved was partial. That really has to be clear evidence, which also brings about the flip side coin, which is that arbitrators must disclose any circumstances which might, in the eyes of the parties, raise to a doubt as to their independence. That is sometimes not being done. And then the question arises, well, is the lack of making a disclosure by an arbitrator, is that in itself a ground to challenge the arbitrator or to set aside the award? Well, the practice of both the arbitration institutions and of state courts in setting aside proceedings is, it varies. There are some courts who say, I think in France, there's been a judgment that says if you fail as an arbitrator to disclose relevant aspects, that might in itself contribute to a finding that the arbitrator was not independent. Whereas in the Netherlands, we have a judgment, although of a lower court, that says that the failure to disclose something by the arbitrator, it does in itself not contribute to a finding of the tribunal or the arbitrator being not independent. And I prefer, I must say, the French approach. In my opinion, if as an arbitrator you fail to disclose something, that is a breach of your mandate, and that should be counted in setting aside proceedings, I would say.
Nilüfer, how is the perspective in America, or from your corporate point of view?
Sure. I think Max was very thorough in identifying some of the key issues here. I would just add a few points. I agree that the seat is of the utmost importance in managing the risk of an international arbitration and managing the risk that an award might be set aside. And certainly from where I sit, when we evaluate international arbitration, potential investments in international arbitration, a key consideration that we look at is where is this ICC case going to be seated? Is it going to be seated in X jurisdiction or Y jurisdiction? And what do the national courts of that jurisdiction say about cases of this nature and so forth? Do we have confidence in the national courts of this particular jurisdiction to uphold the integrity of an award? And just to take a step back, I think for your audience members who are, at in-house legal counsel, and they are sort of before in the pre-dispute stage, when you're still negotiating your contracts, I would encourage you to take, a very close look at the dispute resolution clause and the language that's contained in the dispute resolution clauses of your contracts, particularly your international cross-border contracts, to make sure that they hit the relevant points, that they're clear as to the institution that they've selected. Excuse me, that they've selected an institution that's respected globally and that can produce an award with, of the caliber that will be respected by national courts, as well as that they have a seat that's clearly identified. Sometimes we get these international arbitration clauses where the seat itself is not specified. They might have specified the ICC in Paris as the institution, but that doesn't necessarily imply the French courts or the national courts that would be reviewing it. And one, I guess, practical point that I could give to your audience members that are in-house is that there are a number of law firms that have put out very specific guidance as to what your arbitration clause should say in your international contracts. And one that I'll plug is the Freshfield's Guide to Drafting International Arbitration Clauses. It sets out various considerations that I think any in-house counsel would be remiss not to be aware of, because that's the first step in ensuring that your award itself will will be upheld at the end. I agree with Max also that the constitution of the tribunal is paramount. We also, when we're funding an international arbitration investment, we work with the claimants, we work with their counsel, doing research on the particular arbitrators that they're selecting, both the arbitrator that they're selecting as claimant side or respondent side if we're funding the respondent, as well as who the chair is. A lot of these institutions will use a rank and strike procedure. So we have a lot of institutional knowledge at Omni Bridgeway about various arbitrators, just from what we've seen out there and the research that we've done, that we're able to weigh in on those points. The other thing I would say is that with respect to the disclosure of potential conflicts, that's something that's come up a lot, I think, particularly recently, because a lot of the institutions have revised their rules with respect to disclosure. The ICC changed its guidance a couple of years ago, I think in 2019. ICSID is in the process of revising its rules as well. The LCIA has also become more explicit about saying that arbitrators must disclose relationships with counsel, they must disclose relationships with the other arbitrators on the tribunal, they must disclose relationships with the claimants or the respondents. And it's, as anyone who's worked in this field knows, for a while, everybody sort of knows everybody in some way. So, one day it could be, well, Carolina and Nilüfer sat on this panel on YouTube organized by IASP years ago, and therefore they must have a conflict of interest. So I'd encourage people to look also at the International Bar Association's guidance on conflicts of interest, because that sets out a series of analytical steps that you can take to identify whether there is a conflict, whether counsel has to make a disclosure to the tribunal or the tribunal vice versa needs to make a disclosure to the parties. And it's something you do want to take care of early. You want to take care of it during the formation of the tribunal. It's not something that you want to happen at the end of a few years long international arbitration, because that could really jeopardize the award. I think some national courts have different views on how to analyze that issue. So it really depends on what the seat is. But the best way to protect the integrity of your award is really to disclose and to make sure that you're following the institutional rules and that you're also in compliance with the IBA rules.
Yeah, you're absolutely correct. As to the institutional rules, we also have some changes here in Brazil. CCBC, which is the arbitration chamber of the Brazilian Canadian Chamber of Commerce, has changed its, I think it's CCBC, if I'm not mistaken, has changed its rules as to disclosure by asking the arbitrators to disclose up to 3 years before their relationships. So considering that if some let's say if the arbitrator did some work or had some relationship with the parties or the co-counsels more than 3 years back, then that wouldn't constitute a conflict of interest. So that's very tricky. I think that's one of the trickiest things right now happening in Brazil, especially because there is no appeal to an arbitration award. So what counsels are left with after having an award that's not favorable to their client is that they try to challenge the award. So that's certainly something to think about. And also, I was interested in hearing from you what you think about the constitution of the panel in matters of the expertise of the arbitrators. If you consider it important to have an arbitrator that specializes in, I don't know, procedural law, that understands the rules of the seat, that maybe will keep the procedure on track as to avoid, let's say, some trouble along the way. I don't know how relevant you think that is.
So I think a lot of, I think it is relevant, but I think most arbitrators, the top tier arbitrators are very attuned to that. I think one of the great things about international arbitration versus national court litigation is the flexibility that it offers. So if you have a case that perhaps has a very thorny issue as to where it should be seated, or there is a question of, French procedural law or Dutch procedural law or so forth, English procedural law, you can certainly have, self-select an arbitrator that will be attuned to that. And but I don't know that I'd put emphasis on those particular aspects as a whole, as opposed to what the particular arbitrator brings to the dispute at hand. But it's up to the parties, and I'd emphasize just for the audience that the great thing about international arbitration is that you have the ability to pick at least claimant's arbitrator, or if you're on the respondent side, respondent's arbitrator, and you will have some influence also over the selection of the chair. And all of that is really invaluable versus, at least in the US, if you go to a federal court here, it's whatever judge is assigned to your case. And they'll probably be great, they're on the federal bench, but nonetheless, take advantage of the opportunity, the flexibility, the party autonomy that are the hallmarks of international arbitration.
Yeah, sure. That's also an advantage here in Brazil, I suppose in the Netherlands too, Max?
Absolutely, absolutely. And I'd like to add that sometimes it is indeed sometimes nice to have, not strictly required, to have a chair who is accustomed to applying the National Arbitration Act. Sometimes you can twist it around and appoint an arbitrator as a chairman, a chairperson, I should say again, because that chairperson will or might be more inclined to select a seat if there's a dispute between the parties that is his or her own procedural law. And so in a way of trying to influence the selection of the nationality of the chairperson, you can indirectly influence the seats that will apply to the arbitral proceedings. And that, especially if it concerns, which is not a typical Brazilian subject, but I think it's important, especially if it concerns an intra-EU bilateral investment treaty case or investment treaty case generally. Within the European Union, you don't want to have a seat in the European Union. So you would like to have a seat outside Switzerland or, well, London these days. And then it might help to steer towards a chair that is based either in the US or Brazil or Switzerland or London or wherever, but certainly not in the European Union, because then you will have automatically setting aside issues in ISDS cases. I'm not sure whether there's time, but it reminded me of a situation whereby in-house counsel, we had to appoint arbitrators, and our client were investors, and they wanted to appoint, they suggested to appoint a lawyer that was very much familiar with the dispute already, because that lawyer had represented the investors in an earlier stage of the dispute. And that lawyer was obviously very much in favor of the claim being awarded. Now, that might seem to some in-house counsels a good idea. I think most will agree it's not a good idea, because obviously the arbitrator, if this was a he, if he would be accepted to the tribunal, if he would be appointed, then he would need to make a disclosure. Now, even if he would inappropriately fail to do a disclosure, then you have inherently a risk of the award, if it is in favor of the client, that the award will be set aside. And I think those are pretty obvious risks. But there's another risk that might not be so well realized by parties, and that is within an arbitral tribunal. As soon as arbitrators notice that one of the arbitrators, one of their colleagues, is not independent and is actually trying to decide a case not as an arbitrator but as a counsel for one of the parties, that arbitrator's input will basically be ignored, because it is of no value to the adjudication of the dispute anymore. So in the deliberations of the tribunal, your arbitrator that you thought would help to win the case will in fact not be of any assistance anymore, and the two other arbitrators will decide the case for you. And that is something that you would like to avoid. So never ever appoint someone who you think is in your pocket, because it will backfire.
You're absolutely correct. We have seen that happen here as well. And that just doesn't play well for the reputation of the arbitrator in question, obviously. Yeah. How do you feel about, or how is it abroad? I was wondering about the parties being aware of how many arbitrations the arbitrators are dealing with at the moment, as that being a relevant issue to discuss or to disclose before choosing the panel. Because some of the chambers here in Brazil are considering asking the arbitrators to reveal how many, or not considering, they actually ask the arbitrators to reveal in how many proceedings they are currently active before accepting the position. How is it seen abroad? Is that a relevant fact to consider?
I would encourage the audience members to have that be a question that you ask your party appointed arbitrator, because the most well-respected internet practitioners or arbitration arbitrators out there, they tend to have a very full docket, and they of course they have professional responsibility and ethical obligations to each of the cases that they take, but it's helpful, I think, from where the claimant stands or the respondent stands, to just ask for candid disclosure of the number of active cases and how the timeline looks for the next couple of years. You certainly wouldn't want your arbitrator to be enmeshed in document production challenges for five different cases at the same time. I mean, the way that the normal trajectory of an international arbitration is that it takes several years for things to resolve. So it's not in and of itself a problem that someone has many cases, but it is a problem if all of those cases are going to a hearing at the same time, or if they're going to be in document production at the same time, such that there's a lot of management that's going to be done by the tribunal. It also depends on whether this is the party appointed arbitrator as well as whether it's the president of the tribunal. But I would encourage the audience to ask, when you're considering the various arbitrators, there's obviously a huge slate of arbitrators to choose from globally. What else do you have on your plate? Are you doing 10 other cases? Are you doing, a handful of them? And of course, it depends on the person's career as well, where they are, because it's very hard to get some of these very reputable arbitrators, and they'll say, oh, I have nothing. I have no other case going on.
I fully agree. Also, that I think it's more important to have an idea of the timeline for the next couple of years than the exact number of arbitrators, because arbitrations going on, because some arbitrations proceedings are just suspended or don't take a lot of time, and you can be very busy for the next 2 or 3 years with either 2 or 3 very large cases. So it's more a question of what is the available time, and I think that is appropriately being asked, for instance, by the ICC. When you are appointed an arbitrator, you have to stipulate that you have sufficient time to put into the arbitration that you are being selected for. I think that's a good aspect. And just one side remark is that sometimes, obviously, a party might seek an arbitrator who is too busy, just to avoid that the arbitral proceedings are going too smoothly for that party.
Yeah, you hit a point there, and I would like to comment on that, because sometimes we do indeed see parties preventing the arbitration from going well and smoothly. And one thing that strikes me as important right now at this moment, where everything is being held online and hearings are also being held online, we have seen, I'm talking about internally here at the firm, arbitrations where the party tried to have all hearings, presential hearings, alleging their right of a full defense would be harmed if they held online hearings. So this argument we have seen happening here. I don't know if you've come across this kind of attitudes from parties during arbitrations, and how the tribunals have dealt with that kind of issue.
I think what we've seen is tribunals and parties actually being quite flexible, just because this pandemic has gone on for so long. One of the great things about international arbitration is its flexibility, and national courts, at least in the US, were shuttered for quite some time. It depends on the state. that you're in. But for the most part, court cases really ground to a halt in the US, but arbitrations have continued. It's one of the few areas that's continued. And in part, it's because of the willingness of parties and tribunals to have Zoom hearings. And I think they've had to adopt a lot of flexibility in terms of, you can't have an 8-hour hearing or a 6-hour hearing on Zoom. So instead, A, it doesn't work for people in different time zones, but B, it's just way too exhausting for your brain to be on the screen for so long. So what I've seen is, maybe they do a 2-hour hearing one morning in one time that's convenient for one time zone in one jurisdiction, and then they do another 2-hour, they do the next 2 hours elsewhere. I suspect that there are parties out there that have objected to this because there's certain advantages to delaying an international arbitration, particularly if you're on the losing end of a case that may be quite strong otherwise. But I think the tribunals themselves have largely, and the institutions themselves have adopted this because it just hasn't, you can't not have cases going on for as long as this pandemic has been going on for.
Yeah, again, I fully agree. We have seen an absolute increase in online or virtual hearings. And in the Netherlands, also the state courts have turned to using online hearings. And the Dutch Arbitration Act allows tribunals to have an online hearing, even if one party objects thereto. And I think generally the parties are fine with having online hearings. It works quite well. The downside is, I think that sometimes when in the old days you would have a request by email and a response by email and then a decision by a tribunal, nowadays either party will say, well, let's have an hearing because it's easy to have an online hearing, and let's have an hearing again, and you go from one procedural hearing to another. And that then the intended advantage of being flexible and being efficient might be lost to a certain extent. So I think it's a great tool and it works quite well, but tribunals should be mindful of not, for that reason, allowing a hearing on every single little, issue.
Yeah, and also apart from the hearings, what we've seen here is also that the chambers have allowed for the documents to be filed only electronically. So that has also helped a lot on the practical side of it, that you don't need to file all those 200 pages of claims every time you need to file something. I suppose it's been the same abroad too, right?
Yeah, I think your audience may be familiar with, there's a campaign for greener arbitrations where they really don't want to see any paper. They want everything to be filed electronically. And I think generally speaking that's a great goal. I think we just have to be mindful of jurisdictions where people may not have, great access to the internet or, are able to download large amounts of material. So in some instances, you may still have to send, paper to, whatever country around the globe. But I'd say this makes me think about just technology and international arbitration in general. And I think it's actually really advancing beyond just Zoom. I think people are coming up with more creative ways of doing things. The red fern that I used to see when I was a junior associate in private practice, I think that's going to be revolutionized to a certain extent. I think there's a lot of room for technology to really help advance international arbitration. And I don't know if we've been a little slower just because of the age of international arbitration practitioners or arbitrators that sit on tribunals. But I'm excited for technology to really change things beyond just Zoom hearings. Zoom hearings is a great revolution, but that was sort of imposed upon us. But let's see what else we can do to keep arbitrations moving forward expeditiously and efficiency and meeting the needs of parties, which is what it's designed to do.
I have nothing to add to that.
One last question I have for you that strikes me as relevant as well is how the local courts, in your experience, contribute to the arbitration, if they really defer to the proceedings, if when the arbitral panel needs help, if they are really helpful, or how do you see this cooperation between judiciary and arbitration happening abroad? I would be interested in hearing that from you.
Sure. So U.S. courts, the United States is a signatory to the New York Convention, and then on the investor state side, obviously, to the ICSID Convention, also known as the Washington Convention. So they defer to the standards that are set out in those conventions. The New York Convention has very limited grounds for set-aside proceedings. There's a lot of national jurisprudence in various federal courts in the U.S. that interpret the standards set out in the New York Convention. So I guess the only thing that to highlight about the U.S. is if you have a case that's going to be brought before the Second Circuit, which is covers New York, versus if you have a case that's going to be brought before the Fifth Circuit or reviewed by the Fifth Circuit, that's the appellate level court. The Fifth Circuit is in Texas. They may have a different interpretation of a particular New York Convention ground. So that's something to discuss with your counsel. But I'd say largely U.S. courts, they are very deferential to the arbitral award and to the findings of the tribunal, unless there's something that runs afoul of the New York Convention.
The Western European, or I should say the known arbitration venues in Europe are very much arbitration friendly as well. That is, if you leave aside the inter-EU investment arbitration cases, because that is a completely different story. But within commercial arbitration, I think it's a safe bet to have a seat in the Western European, the known arbitration seats. There are some items that are considered to be of public policies, and those rights, and for instance, consumer rights. If you have an arbitration against a consumer, and you are a company using general conditions in which there's an arbitration clause, that will not work within the European Union. It's very much restricted. Similarly, if there is an issue of European competition law, that will be considered to be public policy as well, so that the arbitration cannot infringe European competition law. And there's a number of issues that are off limits for arbitration. For instance, also corruption. We recently had a case on the I think Venezuelan company Pariven, in which an arbitral award was set aside by the Hague Court of Appeal, because it was believed that, unlike what the tribunal had determined, the Court of Appeal, in setting aside proceedings, held that the agreement that formed the basis for the claim was created after a deed of corruption, and that's why the arbitral tribunal should not have granted the claim, at least not on that ground. So there are some issues of public policy, as in any country, but the filling in of those public policy items may well depend, depending on what continent you are.
Yeah, that's very interesting. You touched upon a very interesting question, which is corruption. I suppose for Niloufar, that's also very relevant when you analyze cases you decide to finance or not, right? How do you see that? What kind of analysis do you do on that issue?
Sure. Yes. No. It's certainly very critical, because it's something that comes up quite frequently in the award and enforcement stage. It's a common defense to the losing party to allege corruption, and something that we consider this at the onset when we're taking on a case and we diligence it. We certainly take an active role in meeting with the claimants, or if we're going to potentially fund the respondent, looking at their documents, having a good understanding of how did this contract get formed, are there any of the hallmark red flags of corruption. We work with the counsel to determine that as well. We have pretty rigorous compliance standards to make sure that we are funding something that doesn't have any of the hallmarks of corruption. So I think it obviously depends on it's a case-by-case basis, but I would encourage your audience members to carefully consider contract formation and contract performance, and ensuring that potential witnesses, the documents that you have, all of those, those are all in order, and none of them evidence what would be considered corruption on the international level, such that it could jeopardize the integrity of an award.
Yeah, that's excellent. Thank you very much. I think we are reaching the end of our presentation, of our seminar, and I would like to ask if you have any other inputs you would like to share with us before we move on to the next panel.
No, I would just like to say thank you so much for including me in this panel. It was a pleasure to be here. It was a pleasure to learn more about the Brazilian market from you, Carolina, and of course to learn more about the Netherlands and Western Europe. I have a number of Dutch colleagues at Omni Bridgeway, which you probably know, but I now feel even more enlightened about the Dutch market based on this panel. And I thank the audience for joining us, and I invite any audience member or any of my fellow panelists to reach out to me if you have any questions or interested in learning more about third-party funding. I'm happy to be in touch with you via email or to schedule another Zoom. So thank you so much for inviting me. It's been a pleasure.
Well, thank you, Niloufar. It was my pleasure as well. So thank you very much. And likewise, if the audience or someone has a question, just let us know. And it will not be able to do that now, but send an email and we will be in touch. Thank you very much, Carolina. Thank you, Niloufar.
I thank you, Max, and you, Niloufar, for this very productive conversation we had today, also in a very light tone to introduce this seminar we are holding today and tomorrow. So I thank you very much for your participation, and I would like to move on to the next panel. We are going to have Danielle Levy and Daniela Haas speaking. And as a moderator, we will have Eric Vinicius de Moura. Eric is an attorney. He is qualified to practice law both in Brazil and the United States. And he is now an independent advisor for the US law firm Berger Montag. And he has obtained his LLB and his LLM in political and economic law at Mackenzie Presbyterian University in Brazil. He has also participated in Columbia's Business Law Academy, Temple's Excelling in Evidence Law program, and is researching legal developments connecting the Brazilian and the American legal system as a visiting scholar at Columbia Law School right now. So Eric, I welcome you today to our second panel, and I wish you all a very productive conversation too in this second part of our seminar.
Thank you very much for the introduction, Carolina. Your words have been very kind when making my introduction. So without focusing on the moderator, let's focus on the speakers, which are the parties that we should highlight on this event. First, I would like to briefly introduce Daniela. Daniela is an investment manager and legal counsel at Omni Bridgeway. She stays in their office in New York. She not only assists Omni Bridgeway in investments that concern US, but also in investments that concern Latin America. Daniela has also obtained her degrees both from Harvard and Berkeley College. So we know we are before someone that's extremely well qualified with a lot of experience in this market. And on the other side, we also have Daniel Levy is a partner at Enya Law, one of the main law firms in the UK. Although they are one of the main law firms in the UK, their practice is not focused entirely in the UK. They are also able to take cases in all of Europe, cases concerning Africa, cases in Latin America. He has a PhD from Université Panthéon in Paris, and Daniel has also assisted in every side of litigation finance and gagging finance, analyzing investments for institutional investors. So we are speaking with we have two speakers that are extremely well qualified. And I would like to begin by making a very general question, just so that we can get the audience and everyone else on the same page. Daniela, if you could start us, introduce us to how do you see what is litigation funding?
Sure. Thank you, Eric, and thank you very much to IASP and to Daniel for participating in what I hope is an interesting and useful discussion. We're excited to be talking to practitioners in Brazil as we kind of increase our efforts in funding in Brazil and throughout Latin America. So in a nutshell, what we call disputes finance, which is, obviously available for both traditional kind of court litigation and arbitration. It is a form of non-recourse finance, and that finance can be used to support legal fees, costs of a litigation or arbitration, and the part that fewer people know about is to support a claimant with working capital, and that can be either in the very beginning stage of a matter or all the way through to the end where you have a judgment or an award in hand and you're looking for assistance in executing an enforcement strategy and funding. So in essence, a party like Omni or another funder, subject to agreed terms, will support the financial needs of the matter on a non-recourse basis, meaning we only make a return on our investment if there are, in fact, recoveries in the matter. So that's a pretty simplified way of describing what it really is.
And Daniel, when you're, for example, assessing investments, how have you seen the parties that are parties in an investment think about litigation finance? How well versed would you say attorneys and companies are to this institution that can be quite helpful?
Thank you, Eric. Well, first of all, just a quick thank you to Yaspi and to Omni Bridgeway, to Eric, and also to Daniela, who is in the panel with me. It's a pleasure to discuss this. Jumping to your question immediately, it really depends on the region, and it really depends on the kind of company. It really depends on a series of factors. As you said, at Enyo in our law firm, we deal with companies from all over the world. We do almost exclusively international litigation. So I would say 100% of our clients are foreign clients. So it's an interesting experience because we can see, how Latin American clients react to funding in a very different way as to Americans or British. And it's interesting because I think there is a very important difference, which is, I would say, Latin America, where there's still a way to go in terms of funding, in terms of knowledge. There is today a lot of knowledge. There are some, a lot of funding options in Latin America. This is, I think, also due to the growing presence of American firms dealing with very big investment cases in Latin America. So they brought with them very good, very well-known funders like Omni and so many others. So I would say today in Latin America as a whole, we could see that most of the Spanish-speaking countries, if you take the sophisticated firms, they are quite aware there is funding available for an investor bringing a treaty claim. And then there is Brazil, and then there is all the commercial claims in Latin America, which I would say are in a second kind of step below in terms of knowledge. So not all those companies involved in commercial cases know there is funding available. And second, and we might develop this throughout our conference, I think there's a lot of companies that still associate funding with impecuniosity, with the fact that I need money because I don't have it. And Daniela just mentioned that one of the big advantages of funding, for example, is just having working capital, just not ruining your cash flow in the middle of a pandemic. And so these are also, I think, important benefits that are not known to a lot of parties. Here in London, I would say funding is widely available. Even, I would say I've never seen in 20 years working as a disputes lawyer so many funding options. So, it doesn't mean it's easy to access the money. I think the due diligence process is still quite tight. And then maybe Daniela can, talk to us a little bit about that. There's still a lot of, very criterious investigations about the case, but there are a lot of offers. And so it's it's easy to say here, everyone knows about it, and it's very widely available. And just to conclude my answer, Eric, I think what is kind of pending here is what will be the trend, what will be the type of case where funding will be available between the growing number of class actions being brought in the UK and individual claims. That's something we can also develop. But I think that's something, there's still a little bit of hesitation here in the case law. And I'm curious to know what is going to be the trend, because I know in the US, where you are, Eric, the class action, the collective suits have been quite a focus of funding. And here I still see a lot of individual claims.
And Daniel, thank you so much for touching upon some of the benefits of litigation funding. And I do think this is a topic that we could try to discuss a little bit, because as well spoken before, sometimes when you're discussing the market, you see people who believe that litigation funding is something that should be used when there's a necessity, when your firm is, for instance, not able to absorb all of the cost of a class action, of a securities dispute, or your company does not have enough capital. But on the other hand, I see there are other scenarios where litigation funding can be seen as a way to mitigate. And I believe Daniela would be extremely well qualified to point out to us how exactly companies and even law firms would be able to benefit from utilizing those services.
Absolutely, and I think Daniel made a very good point that there is a lot of capital in this space now. It's an attractive asset class for investors because, as we all know, it's not correlated to the market, right? A litigation or an arbitration performs independently of market forces for the most part. So there are a lot of funders out there, and it is important to get to know their process and to get to know a few, because there are really important differences, in everything from, whether they're public or not, and their approach and their staffing on a case. But I would say in response to your question, Eric, the one sort of resounding theme that I think every funder will be able to agree on is that this is really becoming much less a tool about sort of helping the impecunious claimant. This is a tool for sophisticated corporates, many of whom are reaching out to us before counsel has even been identified for a case. And we obviously we have a large network of firms who we know are comfortable working with funding, so we're often able to make introductions that way. But what they're looking for is a way to preserve their capital for the core of the business. And what better way to do that than to share in the risk and cost of the litigation with an investor. So that's kind of a no-brainer, right? That you have a third party who, as you said, has undertaken a rigorous, any reputable funder will have undertaken a rigorous diligence process to ensure that the economics of the case, make sense to bring, that at the end of the day, there are likely going to be recoveries remaining, not just for the funder and the law firm, if the firm is working on risk, but also for the claimant. In fact, we aim in any transaction for the majority of the recoveries to be available to the claimant. Otherwise, who would ever want to use this again? And it also kind of throws the sort of alignment and motivations a little bit out of whack if that's not the case. But the other factor I like to talk about a lot, because I think it resonates with a corporate audience, is that this tool can help you with to solve a time problem. The risk sharing and the cost sharing is kind of obvious. But when you are well along in a litigation or an arbitration, and you feel very good about the merits, and you see a defendant who you believe will likely come to the table, that's all well and good, and you may be perfectly happy to allocate part of your budget to pursue that claim. But what is totally out of your hands is how long it may take. And typically, we all know, whether it's a U.S. litigation or an international arbitration or even a local Brazilian litigation, these things take a lot of time. And so what a funder can do is kind of solve the time problem by providing capital. Obviously, the recoveries, the expected recoveries have to justify it, but a funder can offer capital upfront. And that can be in the context of an opt-out from a multi-district litigation or a class action. And it can just be, you know, in the context of a normal case where you may even have counsel working on full risk and covering all expenses, or you're happy to cover expenses, but a funder can offer that upfront kind of form of capital, which can really help with your balance sheet. And the idea is really sort of turning the legal department from just a pure kind of cost center, where you're in a defensive mode and having to pay for fees to defend the company, into thinking creatively about what affirmative claims you might be able to bring and turn into more of a profit center.
I see. And pretty much discussing the affirmative claims that one might be able to bring, I would like to address this question both to you, Daniela, and to you, Daniel. What are the claims that you see likely to be financed in Brazil? What characteristics do you believe a claim in Brazil will need for an international litigation funder to be able to assist the companies or the law firms that have such claims?
I'm happy to throw out some ideas. Look, if nothing else, this entire space is quite nimble and creative. So we're always willing to be persuaded. But I think the most sort of obvious entry points we envision into the Brazilian market, and in fact, the typical inquiries we are already receiving relate to international arbitration matters or enforcement matters. In part, that's just based on our still getting to know Brazilian courts themselves, and kind of the process and timeline it would take to resolve a matter in a Brazilian court. In terms of claim types, we are, I wouldn't say completely agnostic, but we invest in commercial matters, or investor treaty kind of matters, right? But we and that can range from many spaces, from antitrust to sort of breach of contract to fraud claims to insurance coverage claims. It's almost easier to talk about what we do what we don't do than what we do. What we don't do, I would say, is fairly limited to the world that consumer litigation funders tend to support, and that's things like mass tort claims or personal injury claims or malpractice claims. It's possible we could get comfortable with those claims on a portfolio basis with a law firm, but those are not the things that we typically get involved in. And Daniel, you may have other ideas of good kinds of claims in Brazil for funders.
Yes, there are a lot of issues in Brazil in terms of funding. Of course, the delay of our courts is one big problem. When can I get the money back? So what I've seen in Brazil is that funders are much more interested in enforcement than in funding claims, which are just at the very beginning. Even arbitration, sometimes there are very interesting cases of being arbitrated, but then there is still an enforcement proceeding relating to the award, or even maybe sometimes a setting aside. Even if the Brazilian courts are extremely well educated, they are extremely strong in terms of knowing arbitration, respecting the award. But like I like to say, it's not because a judge knows about arbitration, it's not because a judge will reject the annulment of award that this will not go into an appeal, and the appeal will go to another appeal until then there is maybe 10 years just for a final court to say the award is upheld. And so that's something I've been trying to advocate for a long time, which is really trying, Brazil needs to try to have those special courts dealing with arbitration matters, which are already very common in Brazil, in São Paulo, in Rio, in Minas Gerais, if I'm not wrong. But we would need to have like a complete recourse system. So that, you know, we can get an arbitral award that is not pending of a final judgment, of a final enforcement for years and years. So that's why I think it's still very difficult when I talk to my colleagues in funding, in funds, is still a little bit difficult to fund, you know, even domestic arbitrations or even, you know, international arbitrations seated in Brazil. But there are cases. So I think in Brazil, there's still a very, the market is still very concentrated in the funding of precatórios, in the funding of credits, in the funding of, you know, decisions which are completely res judicata. I would say the other way around is that there are cases being funded in Brazil but brought abroad. So cases which are funded because there's, you know, a number of victims in Brazil, but there is an action being brought in Europe for, you know, different reasons that we can discuss if we have some times. But, you know, just as, you know, just an example, you know, all the cases relating to the liability of controller shareholders, you know, which is Article 246 of the Brazilian Corporate Act. Or, you know, cases where the ground is antitrust, or, you know, anyway, trying to bring jurisdiction in other places, in other forum. So I would say those are the two main, I would say from my experience, that's what I've been seeing these last years. And I still think really that there is a lot of opportunity. I think this new kind of direction from Brazil to abroad is kind of expanding as we talk. It's you know, every day there is something new. There are also something new, not only on the side of the funders, but also on the side of the case law here in Europe, with, you know, many interesting decisions about jurisdictions, about foreign shopping, about the limits of those claims. So it's an evolving matter, I would say. And I'm sure, you know, there's a lot of colleagues in funds looking at those cases very, very closely to see what's going to happen, really.
I see. And when you mention you have lots of colleagues looking at those cases, I think it gives us a perfect link. Imagine if I were a company in Brazil, if I were a legal director, or if I were a law firm, and I had a case that I quite believe in, but for any number of reasons, I'm not willing or able to move forward with this claim as it stands right now. What would the litigation funding process encompass? What would the due diligence be? For instance, would only the litigation funder be looking at the claim? Would you hire a different party to look at the claim? For instance, Danielle, have you been requested to perform a due diligence for a litigation funder and check the merits and the procedures of a case? So in short, could you walk us through the process of getting a claim funded from the moment you have a claim until, let's say, you receive an award?
Danielle, I can jump in and then you can complement, because I think Danielle is much better placed to, you know, talk us through the internal side of the funding. But I'd like just to point out two things, and one very important point which Daniela mentioned a little bit earlier. I just wanted to highlight that. It's very interesting how in these last years there is an inversion of, you know, clients that, you know, a couple of years ago, they would come to lawyers and lawyers would refer funding. Now they're kind of going to funders directly, because it's been such a huge market that now, you know, they of course have good contact. So they come to Daniela directly and they say, you know, I have this interesting claim like Eric is mentioning, and then maybe Daniela then will refer them to a lawyer. And so this is the first point I'd like to highlight, which is very important, because it shows how this market is evolving to be kind of almost a financial marketing requiring legal support, and before there was like kind of a legal market which required the financial support. And so it's very interesting, this overlapping between funders and law firms, which are sometimes so overlapped that they are on and one. And we can talk about that later. I know it's very interesting. This is a trend here in the UK, you know. But so That's very interesting. So most of our cases, this last, and that's very, very recent, I would say like 2 or 3 years, this last 2 or 3 years, most of our cases, they've been referred by funders and not by the client directly. What funders, and now answering to your question, Eric, what funders have been, doing, of course, is that
perhaps you're not so sure as to when the meeting had stopped. If you could restart a little bit further down, it would be very helpful.
Sure. I think what I was saying is that I'm very happy to hear Daniel's observations about the market flipping a little bit and turning from litigation funding being something that really lawyers know about and sort of inject into the equation, perhaps when they spot a good claim and want to work with the client, but are aware that the client can't fund the matter on its own. It's exciting to hear that corporates are opening their eyes to this and realizing that it can be a compelling tool to sort of introduce early into the case. I learned about it myself when I was in-house and had some litigation matters that required support. And as I think many of us are aware, funders do like to see risk alignment in a case, and that often involves counsel working on some form of risk sharing, presuming, of course, that the matter is proceeding in a jurisdiction where that is permissible, and it's not everywhere. So in jurisdictions like the UK, for example, we find other ways to kind of align risks, but also to see a claimant participating, if possible, in sharing some of the costs. And the reason for that, there are a few different reasons for that, but funders basically like to see all the parties sort of motivated similarly when it comes to matters like resolution. And so if everybody has skin in the game, then that creates the best kind of alignment around settlement decisions, right? So it's good to hear that, and I think injecting a funder early into the discussion, even with counsel before counsel has been selected, is a really good way to try to get counsel itself pitching the company, the client for the case, and thinking creatively about what kinds of fee arrangements it's willing to entertain when funding is built in, and that can be all the way from kind of full contingency with the funder supporting costs to a more typical kind of risk sharing. So I find that it can be helpful to introduce a funder early on. Similarly, funders will often work with counsel to present funding as an option to a client, and I've been involved in many cases where the client was evaluating working with pure kind of contingency counsel, which it was perhaps very accustomed to, and on the one hand, and on the other hand, working with a funder where the costs would be shared essentially among the funder and the firm. And we've been able to kind of get very granular with detailed models showing the client how, depending on certain recovery scenarios and the timing of those scenarios, the client could actually do better or as well with funding. So it's important, a funder will, if nothing else, inject, I think, a degree of discipline and planning into a case. For some years, people criticize the funding industry as encouraging frivolous, claims by funding, litigation that shouldn't be funded. And I couldn't disagree more. And I think all you need to do is kind of go through the diligence process with a funder once to realize that a lot of questions are asked in the beginning, in the planning stages of the case. And they're not just about the merits. They're about, timing and collectability and jurisdictional risk and counterclaim risk. And really, as with any other kind of asset, the more you can kind of plan and understand it, the better prepared you'll be to sort of finance it, right? So the basic kind of life of a funded case is really three parts. The first would be clearly to sort of have a high-level discussion. Any discussion should be subject to a non-disclosure and confidentiality agreement. Funders are very happy to hear from the lawyers on their sort of views of the case. They'd like to see work product sometimes, but really just get kind of the basic documents supporting the claim, whether it's a draft of the complaint or whether you're farther along and you have, you know, key documents and perhaps deposition testimony and decisions on dispositive motions. And so depending on the complexity of the case, it can take days and perhaps weeks. In some cases, it's been, you know, months. But the funder should be aware that when you're approaching them, it's because you are ready to, you know, pull the trigger and secure financing for the case. So any reputable funder should try to move quickly. Different funders approach that kind of initial view differently. One approach, the approach we take is to have, you know, former practicing litigators and arbitration practitioners assessing the case and putting together what we call a term sheet, which reflects the sort of parameters of a deal and the terms under which the funder is going to dive in and do deeper diligence on the deal. And the reason we like to have, you know, experienced lawyers doing that is because we think that we can price the risk in a case better when the person who's doing the pricing kind of understands the strengths and the hurdles. What we try to avoid is a situation where we move forward with you into diligence and then we can't close. It happens, of course, but then you have to start all over again. So by you know, bringing in sort of experienced lawyers, we try to put together terms we feel confident we can close on. The term sheet is a pretty simple document. It lays out, you know, how much we're willing to invest, what the return would be, what kind of, you know, waterfall we're looking at, meaning as first dollars come in, how they are allocated among the funder, the lawyer, and the claimant. And it's typically not a binding term sheet. The only binding aspect of it is that in the diligence process, we will be taking a good hard look at the claims and the merits and everything else. So we would ask to do that under exclusivity, meaning you're welcome to talk to as many funders as you want. But when we are in exclusivity, we ask that you stop doing that because we will go typically out of pocket and hire someone like Daniel to help us assess the case. And that process itself, I think, is another major benefit of the funding process because it will be an opportunity to vet and legitimate and even ask questions about the sort of roadmap and the strategy. And, you know, it will be sometimes an opportunity to kind of button up any open questions and address any risks that you really want to be addressing early. So then a typical funder process would involve a couple of conversations between litigation counsel, the company, and the funder's diligence counsel, and really the funder preparing the matter for presentation to the investment committee. In our case, it's, you know, a committee of senior management and former judges and former practitioners who know the jurisdictions well in which we are contemplating funding. In parallel, in most cases, we would be also negotiating the final documentation of the funding agreement. Every funder handles that differently. Some like to complete the merits diligence first and then move on to deal documentation. Many try to do it, you know, in parallel so that by the time we have approval on the investment, we are able to close and immediately begin funding. And again, every funder's sort of role once a case is in fact funded is going to be slightly different. Here in the US, we take a pretty hands-off approach. We are very respectful of the fact that it's the lawyers who are defining the litigation strategy and the clients who are making all decisions, in particular around settlement. So we take a lighter hand. We will ask to be informed of material developments as the case proceeds. We may have an opinion, but ultimately that authority is going to rest with the client. And again, there are many funders who are kind of pure kind of capital players, and they may take a different approach. Our philosophy, and the philosophy shared by many other funders, is that, again, you want a lawyer who is experienced, being your partner through the life of a funded case, because we all know that litigation and arbitration matters take unexpected turns, and what you want is an experienced funder who has kind of the committed capital and the sort of the track record to help you navigate through any challenges once a case is funded. So that's my long-winded explanation of the funding process.
That's fantastic, and I'm quite sure the members of our audience will be able to have a very good and very clear understanding of what they should expect when it comes to financing a case. And you touched upon a subject that I believe would be valuable to those watching us, which is, you mentioned there are many different litigation funders. We have funders who act in X or Y manners. And overall, Daniela, how would we know whether our litigation funder is a good partner? Imagine I were a company and I have a case that I believe in that's quite strong in the merits. The facts are also very, very feasible. And I want to approach a litigation funder. I go after a litigation funder. I don't know, I Google, I search materials, I ask around, and I have 5 different names in front of me. How would I be able to properly assess which litigation funder is a reputable, is a, let's call, a good litigation funder? And sorry for sounding so simple, but at the end of the day, we want to be able to have the case funded by someone we could trust.
Well, Eric, I think the good litigation funding is the one that funds your case. But to come to that, I'm just kidding, of course, but to come to that, I think at least from the attorney's perspective today, I think the funder is the one which is, I think the one who is transparent from the beginning, from the outset, in terms of how the potential of funding a case. There's a lot of funders that might just waste time going through due diligence and just, lock the case into a drawer, and then we just forget it is being due diligenced. And, at the end of the day, the funder would be able sometimes to just have a very first superficial look and say no. And I think we've had experiences here where funders took, an awful lot of time to say no. And, others who just came back to us very quickly and said no. And so a quick no is much better. So that's what I call like this transparency, that's the idea of being able to really work together with the lawyers. And another thing which is very important for a law firm is a funder that could work together constructively. I mean, if I go to Daniela with a case, I'm not always looking for a yes or no answer. I'm looking maybe for her to, take me through some steps, which might help me fund the case if it's not ready to be funded. So this kind of, this evolving dialogue between the law firm and the funder is quite important. I know, some law firms don't have time for that. Some funders don't have time for that. But from my experience, I had cases where, clients came from funders with, a very, very poor case, or very, very, difficult cases, and that was the words of the funder, and then we started working together as a true triangle, which is this relation between law firm, funding, and client, to try to look at different aspects, different angles, because as lawyers we can look at different legal angles, but we are not in a position to look at different financial perspectives and financial returns, which is something funders can do. So I think having this continuous dialogue is quite important with funders. And finally, which is of course a cliche, but it's absolutely true, which is trust. I think funders need to trust the lawyers. I think especially now when, there's a lot of clients coming from funders, if the funders instruct a firm or if the funders recommend a firm to a client, the funder needs to trust them. I'm not saying that the funder needs to have, to step back from the case. And I personally really like funders to be involved in a certain way because I think having someone like Daniela or having someone who is experienced on that, it's absolutely a benefit of the funding to have someone who can, help us look at other angles, look at other arguments, and to be this intermediate in terms of, how we can deal with the case. So I'm not against it. To be honest, I know a lot of colleagues have been worried lately about, funders that have been very, very interventive in cases, even, calling arbitrators to interview them and things which I know happen. But I'm very open to that, really, because if we know the funder, if we like to work with them, it's quite a pleasant experience to have this team built up for the same interest. So I think we need to be very aware that today there will be a growing overlap, a growing, I would say, proximity, a growing closeness between funders and law firms, and that it's very important that we get along together in a very smooth way. So that's what I am looking. I'm also looking on a more concrete point for where's the money coming from. I think that's been very important, especially for companies, not maybe so much on the claimant side, sorry, not the claimant side, but not so much on individuals or class actions. But when we're talking about companies, especially multinational companies, in the times where compliance is everything, we need to know where's the money coming from. We need to do our due diligence, and this is quite a requirement I've been getting from my clients. We're happy to look at some funding options, for example, if we're talking about enforcement, but I want to know where is this money coming from. There is a lot of money out there, so we need to know exactly how good, how legit is the money we're gonna fund our case. Yeah.
I would just add to that. I couldn't agree more. I think it's really important to understand the backing of a funder, not just, are there quality, institutional investors behind the fund, but how much is under management? Is the funder raising capital to fund this opportunity? Which I do hear a lot, or do they have a committed fund already there that will support the life of the case and all of the other cases that the funder has invested in? And I strongly believe that a funder who can't be transparent about that is a funder you want to be cautious about. The other thing I would say is that it's a lot more than a pure sort of economic relationship. Obviously, a funder's pricing is really important, and funders spend a lot of time kind of studying the market and trying to make sure that their proposed returns are reasonable and kind of aligned with what others are doing. And there's, I wouldn't say standardization, but certainly an effort to sort of observe a market, right? But I think it's very important to get to know funders who have experience and a track record. And part of that means the risk that they will say no. But, and we do say no a lot, but I think it's important to understand that one of the reasons a funder will say no is not just that they don't feel that they can make their return in the case. In fact, if anything, funders typically will look to recover whatever they funded first in the waterfall, and possibly even go, pro rata, share with the firm on the firm's percent if it has one, and the remainder of our return. And typically the balance of the recoveries would then go to the claimant. So often a funder is well taken care of in the waterfall. However, any responsible funder is going to want to make sure and going to ask a lot of questions about expected recoveries, not just the ask, not just the damages you're looking for, but where you expect the case to resolve if it resolves before trial, which is obviously where we would like it to resolve, because trial is the most risky stage of a case, right? So any responsible funder will spend a lot of time comparing the funding request to the expected recoveries. And the reason for that is that a funder who has been at this for a long time and intends to stay in it for as long, we want to make sure that the expected recoveries are sufficient to pay not only itself and the attorneys, if they're entitled to a percent, but also have the company doing very well. And so most cases, when we say no, it's because we don't feel that there is a good ratio between the funding ask and the expected damages. And that can be problematic in the case that we're funding itself, because a company may say, no, it's perfectly fine. And they may mean it on day one. It's perfectly fine if I'm only going to receive 20% of recoveries in that situation. I don't mind. And they may mean it. There could be other reasons to bring the litigation, and that could be just a fine outcome. But as the case goes on for 3, 4, 5, maybe even more years than that, that can start to feel not so good. And so we really want to make sure that through the life of the case, that the claimant is going to be motivated in any likely outcome. And even a claimant who is perfectly willing to sort of honor the deal they made if it winds up that they receive only a small portion of the recoveries. Our feeling is that they're probably not going to want to do this again. So we sort of view ourselves as long-term players in this industry and stewards of the industry, where if people don't have good experiences, they're not likely going to want to do it again. So any responsible funder, I think, will look very carefully and talk to the attorneys about what they're expecting, and talk to the company about what they're aiming for, and only propose a deal that they feel confident will be good for all of the parties involved.
That's extremely enlightening. And this connects me to one thought that I had while you were explaining the situation. Are there any potential conflicts of interest? One situation that I can think about is, for instance, if we were in the final stage of a case or even before trial, and we have a settlement offer and the client believes X amount is what the lawsuit would likely recover. The funder may believe that Y amount is the likely recovery. How would the parties be able to balance those perhaps different interests?
So as I think I tried to say before, funders are there at the table and may have a view, but we will be very careful in our approach and in our deal documentation to not give ourselves control rights over settlement. And there have been, situations in which, we may recommend a settlement that the client doesn't want to take, and we live with the client's decision, or conversely, we don't like a settlement that the client does want to take, and ultimately we recognize that it's not the funder's decision. Hopefully we've already done our work, which is set up a deal that works well under a variety of circumstances, but we will be very respectful of the client's ultimate control over the litigation. Daniel, I don't know if you want to weigh in on that also.
Yeah, I completely agree. I think that's one aspect of conflicts. I would just add the other aspects of conflicts, which is issue conflict, which is the conflict between funders and, for example, an arbitral tribunal, or funders and lawyers. I think for the first time, the ICC provided for the issue in their 2021 rules. I just noted as Article 11.7 of the ICC rules. which is aimed at, disclosing funding to avoid conflict of interest between, the funder and the arbitral tribunal. And that's very interesting. That's kind of interesting choice of the ICC to provide that on the rules, which means there is a general consensus, there is a general, concept that, like I said, funders will be each time more participating in the proceedings. So I'm not saying that in all, arbitration proceedings, funders will be disclosed, but from my experience, there is a very, very, it's been very common for one party to ask for the disclosure of any funding arrangements. I'm not saying the arrangement, the agreement itself will just be disclosed, but the existence of it might be disclosed, especially because there's a growing trend towards requesting applications of security for costs. And as soon as you apply for security for costs, one party will say, I don't need security for costs because I'm being funded. And then, well, then present me, the redacted agreement, or I want to know who we're funding. And so funders will be each time more third parties in an arbitration procedure. I think it would be an illusion to say funders will only be these financial guys who have the money and will allow a lot of claims to go on. I think that's a misconception. I think funders are starting to get very close to the lawyers, are starting to become lawyers sometimes, and some lawyers are becoming funders. So I think that's going to raise a lot of conflicts. I think that's going to raise, I think that's going to be a very interesting topic. And I think if anyone, there are some very interesting studies on that, but I think it's still a very interesting topic if anyone wants to, a very interesting topic for a future master's degree or PhD is the participation of funders as third parties in international arbitration. I think that's quite common today.
Extremely interesting. And I believe time will allow us for one more question. And I would like to try to highlight the Brazilian market to our audience as much as possible. And I would like to direct this, at least initially, to Daniel. How do you see the current politics affecting litigation funding? Do you see this having any issue whatsoever? Perhaps when it comes to the chance that would be approved, when it comes perhaps, Daniela, to pricing?
Well, I can then answer on the chances, then maybe Daniela can answer on the price. I think in terms of getting approval, I think these last years, the Brazilian political situation has had some impact in, the overall economic outlook. I think a couple of examples which I've faced this last year or so in terms of funding, one client coming to me with a very big Brazilian case in reais, but when converted to dollars, that was kind of a very average case for a US fund. And so when I went to speak with my colleagues in London for this specific case, they said, I know this is a very big Brazilian case, but if we convert to dollars, which at the time was like 1 to 6 or 1 to 7, that becomes a smallish case for us. So we're not here very sure we can fund that. So I think, for example, the valuation of currency, it's something that turns a lot of funding very difficult in Brazil. We're talking about cases, and then Daniela, of course, may give a more accurate information, but I would say, if the case is not 100 or 200 million reais, it's difficult to fund it because we're talking about cases which will be, $50-60 million max. And I'm not sure how, interesting this is for a funder. And that's a very big case in Brazil sometimes. If we take today all the infrastructure cases in the energy sector, those are, the big cases are 200, 300, 400, etc., etc. A second aspect is the access to credit for companies. Interests were very low in Brazil, so it was very easy to access credit. So instead of going to a funder, just go to the bank. And I think that was something which was also, kind of preventing a lot of companies to go to funders. They would just, it's much easier. I already have a pre-approved loan to be paid, 30 years. And that's, record low interests for Brazilian standards. Now that Brazilian interests are starting to raise again, it's going to be very interesting to see if maybe companies will start looking at banks on a more, conservative way, and that might be, a good explanation why they would go to funders. And last aspect, which is not, Eric, it's not really related to the political outlook of Brazil, but I would like to put it as from a personal experience. I've been in Brazil for 10 years. And I think one aspect of the Brazilian legal system which would prevent funding, or at least turning funding not so interesting, is contingency fees. Brazil is one of the places I know where contingency fees for litigation and arbitration are most common. Almost all our engagement letters for big cases would have, at least a percentage at the end as contingency. So at the end of the day, it's almost if the law firm was investing in the case. So why would we go to funders if 10 or 20% is contingency? And when the big law firms, and I think and to be honest, I'm not anymore into the market in Brazil, so I don't know how this is moving. But we know when the law firms starting to bill as we do here in London, or as lawyers do in New York, which is less contingency and more pro labore or hourly rates, then funding becomes important. But for a long time, Brazilian firms took the place of funders. So I think that's also a characteristic that explain why maybe the funding industry didn't grow up so fast as it's doing now. And I would say that, closes my remarks in terms of, my experience as a lawyer for the Brazilian outlook.
I think it's a very interesting and valid comparison to sort of look at what rates are available from a traditional lender as compared to a funder, and I think it kind of goes without saying that one of the key differences there is that funding is typically non-recourse. So the bank will collect that interest, every month, irrespective of the performance of the kind of underlying collateral. Whereas a funder, after having done their homework and invested in a case they expect to do well, will only collect if they were right. And if they weren't, then the funder is out of luck. I also think it's an interesting observation that the contingency legal market is very well developed in Brazil, and I would think that as in the U.S. with firms that are already working frequently on a contingency basis, there is inherently going to be a limit as to how many matters the firm can do on full contingency. So funding can be a sort of useful bridge to help a firm partially fund a case that otherwise it is very happy to invest in completely. Similarly, with respect to costs, many contingency arrangements often contemplate that the client will be fronting, out-of-pocket costs and expenses, whether it's tribunal costs or deposition costs and things like that. And so in those situations, the funder could be perfectly happy for the firm to continue working on risk, but the client may need help with costs, and the funder can step in with a costs-only funding arrangement. The one word I'll say about sort of Brazilian, the political landscape and where funding fits in, my sense from having had many conversations is that the element of funding focused towards asset recovery and enforcement has a huge potential to take off in Brazil. This is where you've got a judgment. It's a solid judgment. The main risk is over, or an award. Clearly, the main risk is over because the merits have been determined. But you have a defendant who is not willing to come to the table, and there are so many people I talk to, lawyers and companies, who, when you mention that this enforcement funding is available, the wheels start spinning, and they all remember that they have a judgment or an award that's just sitting there collecting dust because no one knows what to do with it, and no one has the appetite to spend even more money to go and collect. So my sense is that that's a very valuable sort of introduction to the conversation right now. and that a lot of the opportunities that we become involved in will be in that space.
So I would like to thank you very much, Daniela and Daniel. I would like to ask both of you whether you have any final thoughts that you would like to share. And this has given everyone in the Brazilian market incredible insight in perhaps at least a tool that could be utilized much more prominently to assist law firms and companies.
I would suggest, oh, sorry. I was just going to suggest that you make it you add to your list, the sort of goal of getting to know a few funders, so that this is something you are able to introduce to the conversation at the right time. There are many different approaches and many great funders out there, and the best way to learn about it is to pick up the phone and talk to a few of them. We're always happy to get to know you and to introduce ourselves and describe our process. You don't need to come to us with a 20-page case summary and your quantum report. I mean, we'll take that if you have it. It's a luxury, but it's a very easy conversation, and we can either generally sort of describe more about it, but also give you a sense as to whether we think the case is a good candidate for funding. So any good funder will be happy to have those kinds of conversations.
So I was going, it's funny that Daniela says that, because I was going to say, I always have, some good friends which are funders, because that's exactly, I agree 100% with Daniela. I think, one thing I can say about any funder I've had contact, and I've had with a lot of funders, they are always open for initial conversation. So never be shy, about just picking the phone and calling Daniela or calling another funder that and say, well, I have this idea. What do you think? Funders are normally extremely bright people looking to extremely high profile cases. So they know sometimes, they have this instinct sometimes from a very, very initial conversation that this will or will not gonna fly. And then you can introduce you to your client and take it from there. And so I think sometimes people ask me, what you think we are missing sometimes, in certain jurisdictions to develop funding, is the proximity of funders with people. And that's not the fault of funders. It's kind of this idea that funders are sometimes these creatures which are, lying on top of millions of dollars, and they're not, and so that's something, one of the first case law, one of the first precedents in the UK about third-party funding, it was said that, funding is an essential part of the justice system. And I think it is. I think it's a very useful tool if we know how to use it. If we use it in the right claims. And, in the UK, we are even, obliged in our letter of engagements to offer it to any clients. It's a deontological obligation. So it shows how important it is in certain jurisdictions. And I think, Brazil is starting to have a very, very fruitful market for funding cases. And I think we should, take this wave and start looking at that in a very, continue looking at that in a very serious manner from now on.
Again, thank you so much. It was incredibly insightful. And now, addressing the audience, I ask that connect tomorrow. We're going to have very interesting discussions about antitrust and securities pretty much at the same time. Again, thank you so much, everyone. Thank you for IASP, and hope to see everyone tomorrow.
Thank you.
Thanks a lot.